We spoke about the 2-year span for the COVID bill. Now, the idea that we could have gone through a 6-month period, would that have sufficed, extending along the way when necessary? Would that have been a good option for us?
Within the state of
for the act.
Oh, for the
so
act.
instead of giving it a 2-year life period, could we have given it 6 months, and after the 6 months do a review?
But guess what, Lisa? The way it is drafted, we could give it 3 months. Because section 66, subject to subsection 2, this act expires 2 years after its commencement. The minister may, on the recommendation of the chief medical officer, by order published in the Gazette, extend or shorten the expiry of this act under subsection 1. An order made under subsection 2 is subject to an affirmative resolution of Parliament. So let me deal with the first part. And then, so the 2 years, this is something that I didn't define. We deferred, as we've done throughout, without fail. We have deferred to the advice of the CMO and her medical team. I have a great deal of respect for those individuals. So when the CMO indicated that WHO, CARPHA, and the PAHO, they've all agreed that this is the time frame within which we are to deal with this disease, COVID-19. Not measles, not chickenpox, COVID-19. This is where the 2 years came from. And we decided on a formula whereby if it is shortened, because we know about the Russians, the Indians, the Chinese, some other European countries are working towards this vaccine, as well as the US. So within 2 months, we may well have the capacity to arrest this disease. So this is where the trigger comes in to, by way of order, publish in the Gazette, shorten, or, Lord forbid, we go beyond the 2 years. But here's the caveat. It is subject to an affirmative resolution of Parliament, which means that resolution has to be brought before Parliament.
So the minister can't sit at her desk and make a phone call and say it's over?
Absolutely not. Absolutely not. For the 2 years, she need not do anything. And at the 2-year period, that will be the end of the act, the sunset clause. But if it is deemed necessary to shorten it or lengthen it, she cannot. In our case, it's a female minister, Minister Isaac, would not be able to do that without Parliament's intervention by what we call affirmative resolution.
In the very beginning of the bill, the act, we have the creation of the command center.
Yes.
That has drawn some question as well. The makeup of the center, we have the CMO, the various representatives from the government there. Should there have been someone from the private sector, civil society, included in the command center? Should broaden.
Okay. So, you said the CMO and other government.
Yes, so we do have
so
the permanent secretaries from
correct.
tourism,
so
health,
this is where I'm going, because persons need to appreciate, first of all, that the command center is not a new phenomena. Under the state of emergency, the competent authority, the Prime Minister, came up with the idea to have this command center. It's now codified, it's now been refined, it's now included in this piece of legislation. So what you have here is, one, a chairperson who is appointed by cabinet. Number two,
why does that person not need be the Minister for Health? Because if the Minister for Health is the competent authority for the act, within the act.
That's a good question, but you have other stakeholders. Why not the Minister of Tourism? Why not the Minister of Finance? Why not the Minister of Equity? They all could put a legitimate case to chair this command center. And we also have to be mindful that the Ministry of Health is represented here.
We
Right?
do have the Commissioner of Police.
You have the Commissioner
there.
of Police.
We have the National Emergency
Correct,
Management
NEMO.
Organization. The Tourism Authority
Right.
is there as well. The
Yeah.
Principal Information Officer for the Government Information
Correct.
Service.
Right.
And where the members shall be appointed by Cabinet on terms and conditions
Correct.
determined. But there's also a provision within the Act here
7.3.
where it speaks to co-opting.
Correct.
Individuals
I was
to come to
about to get to
meetings.
that. I was about to get to that because you will notice in the formal composition that is under Section 6.1, you do not see the Ministry of Equity. You do not see the Ministry of a representative of the Ministry of Education. You do not see the Attorney General. We're not here. But Section 7.3, and if I could read it,
Yes.
the chairperson or the deputy chairperson of the command center may co-opt a person to attend the meeting of the command center at which it is proposed to deal with a particular matter to assist or advise the command center. So by invitation, you bring in the persons, similar to what happened with AG's Chambers. There may not be a necessity for us to be at every meeting, but whenever the legal advice is required, we are a phone call away, or we can be invited to come and advise, prepare an opinion. So whatever they need to get the work done, they have the power to, as the legislation says, co-opt that skill set.
So this doesn't preclude them from calling in any
Absolutely
other,
not.
whether it be the National Youth Council,
Absolutely
taxi
not.
associations, and so forth, so
Yes.
people can
and
come
and
in.
we could look at the composition of NEMAC.
Yes.
NEMAC filled the conference center at the financial center. So you can't have a group of decision makers being such a large body. Anyone who has participated in these meetings, you need a core group of persons, and as per custom, you call in whomever else you need to assist in the decision making process.
So the command center, in a sense, is really a sort of nucleus.
There you go.
And from there, then anything
Absolutely.
can mushroom, can
Absolutely.
branch out.